Yes.
My lord, I beg to make a mention of item 6 of the hearing list, my lord. My lord, here I was to produce the list, my lord, of the schools taken over by the district council schools taken over by the government, my lord, in the West Khas Hills area, my lord. So, my lord, I am yet to receive it. Probably I'll receive it today or tomorrow. So, if the matter can be, it may come up next week, my lord.
Who's appearing for the petitioner?
Well, petitioner counsel is A. Momin, my lord. Of course, I have informed one of his junior colleagues. She was here, in fact, this moment, just a while ago. So I already informed my lord.
Informing them is one thing, getting their consent is another thing.
Yes, they were okay, my lord.
On pre-meet by G appearing for the state respondent, matter is adjourned. This is team up to.
For item number 6.
Yes.
Yes, any objection?
No, Your Lordship.
Lordship, my lord.
This is matter of 2 weeks.
Obliged, my lord.
May I please, Your Lordship, I beg to mention item number 8, Lordship. Let this matter must become after 1 week, Lordship. Or 2 weeks.
What is this matter about?
Termination of a employee, my lord, from the district council.
Council.
District council, my lord.
On pre-meet by the petitioner. This is matter of 2 weeks.
I do personally.
Please, Your Lordship. I beg to mention item number 12. Let this matter come up after 2 weeks, Your Lordship.
You're for?
I'm for the petitioner, Your Lordship.
No objections, my lord.
On pre-meet by the petitioner, this is matter of 2 weeks.
Similar prayer for item number 11, Your Lordship. I'm for respondent number 1.
Why? I think this court has made it very clear that the matter is to be taken up today.
Because the conducting counsel is out of station, Your Lordship. Let this matter come on Friday, Your Lordship.
Lordship, Friday, Mr. Paul is having difficulties Friday.
What on Friday?
1 week, Your Lordship.
Accommodation is sought for by the counsel for the respondent, to which the counsel for the petitioner has no review petitioner has no objection. Accordingly, matters adjourned. This is after 2 weeks.
Item number 4, my lord. I've taken consent of my learned friend, and this matter could be listed after 2 weeks, my lord.
No objection.
But this matter has been heard substantially.
It was in the month of February, Your Lordship. March.
Heard.
It will be next week then, my lord. It was part hard, and certain affidavit was filed by the private respondent, my lord.
Oh.
By the
That
private
was
respondent.
then again rejoinder was filed.
So what is the stage now?
This is NOCMA matter. Is now ready for final hearing, my
Ready
lord.
for final hearing?
Yes, yes, my lord.
With regard to that,
Error was there in the affidavit.
in the name.
Yes, yes.
Yes, Your Lordship. There was an error, typographical error in the name of the deponent, which was rectified by the counsel
Subsequent
for the,
affidavit.
respondent number 4 with the leave of this court. And against that, I have also filed a rejoinder. And the matter can be heard, Your Lordship.
Premiered by the parties, this is matter after 2 weeks.
My lord.
Please, Your Lordship. Lordship, I beg to make a mention of item number 5, Your Lordship. Lordship, we need some accommodation in this matter, Your Lordship. We need some more time to prepare this matter, Your Lordship. I pray if this matter be listed after 2 weeks, Your Lordship.
No objection, Your Lordship.
The counsel for the petitioner has submitted that this matter may be adjourned today since the conducting counsel is not prepared for the same today. On the prayer not being objected to by respondent, by the state respondent, this is matter to prayer law, this is matter to 2 weeks.
Obliged, Your Lordship.
Lordship, similar prayer for item number 13, Your Lordship. I pray if this matter be listed after 2 weeks, Your Lordship.
I appear for this date, my lord. I don't have any objection.
And for respondent number 6, Your Lordship.
On premium with petitioner, not objected to by respondents, list this matter after 2 weeks.
Obliged, Your Lordship.
Wait, please, Lordship. Lordship, I beg to mention item number 10, Lordship.
10 already mentioned.
Item number 10, Lordship.
10 is already mentioned.
10 was not mentioned, my lord.
Not
Not
mentioned.
mistaken, 11 was mentioned, my lord.
Or 11.
Lordship, I'm praying for 1 week's time, Lordship.
What is this matter about?
Lordship, this is regarding the regularization of a teacher, Lordship.
On payment by the petitioner, not objected to by the but how is the union also involved in this case?
Yes, Your Lordship, I'm appearing on behalf of respondent number 5.
The teacher of which school?
My lord,
Langpi School.
in fact, my lord, our service is long discontinued, my lord. This is the second or third round of litigation, my lord.
Second round of litigation, Lordship.
The payment petition not objected to by respondent. List this matter after 2 weeks.
Obliged, Lordship.
Please, Your Lordship. I beg to mention item number 9, Lordship.
In this way, no matter can be heard then.
I pray for some more time, Lordship, in this matter.
On payment by petitioner, list this matter after 2 weeks.
Highly obliged, Lordship.
Lordship, I beg to mention item 7. Kindly pray for 2 weeks' time, Your Lordship.
It'll be 3 weeks, Your Lordship, then.
On payment by the petitioner, list this matter after 3 weeks.
Obliged, Lord.
On supplementary cost list, item number 1.
Yes.
Please, Your Lordship, Land Council for the petitioner is not here. Actually, it is.
And out to board.
Yes, Your
The
Lordship. I'll inform him.
please.
Item number 2.
May I please show?
May it please Your Lordship.
Yes.
Lordship, in this matter, petitioner has filed a petition, if Lordship may kindly recall, to delete the Lokaita as a party in this case. A reply is required to be filed against the petition. Lordship, if I can pray for 2 weeks' time in this matter to file a reply.
Why is a reply necessary?
Lordship, because in addition to the legal issue which has been raised, there are certain factual averments also connected to the legal issue, which may require a small reply on facts. As far as the law is concerned,
My friend has sought time on 31st for filing reply this matter and connected matter also.
That is item 3. Lordship, if I can point out that this petition filed by petitioner has been filed after 2 years of the institution of the petition. So if I'm asking for 2 weeks, my lord, that may be accommodated.
I'm not objecting to it, but what I'm saying that on 31st, Jan have already been solved, so matter is had once and for all.
See, what happened is we are only at the stage of the preliminary issues.
Yes.
The merits of the petition is yet to be looked into. I don't know whether we'll get there or not.
If the issue of locus, the locus, my locus and the petitioner's locus is decided, that we are confident, my lord, that will bring an end to the matter.
Mr. S. Jindal, counsel for the respondent number 1 and 2 respectively, has sought for accommodation inasmuch as the prayer is made for filing of the response to the petition filed by the petitioner seeking deletion of the names of the respondents 1 and 2 from this proceeding.
May I please, Your Lordship? I'm for respondent number 3.
Miss, I'm dictating an order. Now I've forgotten what I've dictated. Yes, what is, you are also in this case?
Yes, Lordship. I'm respondent
who are
number
you?
3, Lordship.
You're respondent 3?
Yes, Lordship.
And who are you?
I'm the complainant in the local.
And what is your role here? What is your submission?
Similar prayer that we will file the objection, Lordship.
How long to last? The said petition may be allowed to be filed within the next date fix. The said response. Similar prayer is also made by the respondent number 3 in this matter. On consideration of the prayer made, the same is allowed. This is matter of 2 weeks.
2 weeks, ma'am.
2 weeks.
Much obliged, Lordship.
Lordship, similar is the position in item number 3.
Similar application has been filed, my lord.
Item 3.
Item 3, Lordship, of today's list.
Yes.
Let it be called up. Because we have item 2 there in between.
Lordship. Item number 2.
Now they are entering up in this.
Why would you, this application for
Condonation of
delay?
delay, sir.
Ms. Learned Counsel has submitted that she is entering queries on behalf of the respondent number 3 and has sought for time to file the response to the application filed by the petitioner seeking condonation of delay for filing of the related application. On consideration of the submission made, seems allowed. Let the response be filed within the next date fix. This is matter of 3 weeks.
Item number 3.
So, who's the petitioner here?
I'm for the petitioner, my lord. We have also filed a similar application for striking out the names of the respondent 2 and 3, which is the Lokayukta lordship. That is Miss Case number 208, my lord.
And the state is the respondent here?
My lord, yes, state is respondent number 1 and 5. 1 and 5.
So the issues here are identical with the other case?
Item number 1.
Yes, my lord, they're challenging.
On merits, my lord, there is slight difference. But as far as the petitions are concerned for striking out the name,
No, that is
they are more or less the same.
that is beside the point.
But they flow from the same order. They come out of the same order.
Same.
So you're making the same submission, Mr. Jindal?
Yes, yes, ma'am.
Same order. Jaka to respondent 3. Uni hangni long respondent 2 and 3. To PT sama long 4. Same order.
Much obliged.
Second call from supplementary cost list, item number 1.
Apologize, Lordship. I was not here when you was called earlier.
That is why opportunity was given to you.
Thank you.
To appear.
Deeply obliged. Lordship, briefly, this is a repetition for a speedy disposal of an objection which is lying there before the sub-registrar. The objection is against a deed that I have executed since 2019. There were letters and correspondence which I have given to the sub-registrar to dispose the objection. They had reverted back a letter to me to come and appear before them. There was certain written petition, and from the other side who had objected also had submitted. But the sub-registrar had not disposed of the objection. So this is mainly the...
Is it related to section 77?
No, not at all.
Not really.
This briefly, Archie, what happens is that my mother, during her lifetime, is the owner of a property of in Maukasiang. Due to certain interference and disturbance by the Darbar Shinong of Maukasiang, mainly the headman and the secretary, I had filed a suit. My mother had filed a suit. That is in the year 1996, which was disposed of in 1998 in favor of my mother. Now, on the basis of that judgment and that she had got a decree, on the basis of that decree, she obtained a registration from the Himamalayam. Himamalayam had registered the property in her name. Now, unfortunately, after her death, I being the son, I had approached the sub-registrar to register the deed of declaration. However, because there was some kind of an objection which was lying there in sub-registrar, maybe at a time when the suit was pending, or maybe after that, I do not know, I don't have a copy of that. Because of that objection, my registration deed of declaration was held. Now, I had requested the sub-registrar to dispose that objection. So, after that, there were letters and to appear before them, before the sub-registrar. Till date, it has not been disposed of. Since 2019 till date.
You have appeared?
Yes, I have appeared. I have filed the written petition. Now, just a simple prayer. I'm asking that to dispose of the objection within a specific time frame. That is the only prayer I'm asking. And in addition to that, I'm asking that if the objection is disposed of in my favor, and again a time frame may be fixed for that. That is all I'm asking.
Why is the sub-registrar sitting on the...
Please, Your Lordship, one private respondent is also there. And I have to seek instruction, Your Lordship. So, Your Lordship, may I please?
Simple matter. You have to dispose it of. See, whether this way or that way, it's up to you.
No, Your Lordship,
I'm not asking Your Lordship to decide in my favor if the deed of declaration should be registered in my name. I'm not asking. I'm just asking Your Lordship to just direct the sub-registrar that particular objection to dispose it of within a specific time frame.
But Your Lordship, since private respondent is there and there is a High Court order also, Your Lordship, I may be allowed to seek instruction from the Deputy Commissioner.
You do that. You have to take steps then.
Okay, I'll take steps. So you're appearing.
1, 2, 3.
Mr. Counsel for the petitioner. Ms. S. Bursaji, G has entered appearance on behalf of respondent 1, 2 and 3 respectively, and as such no formal notice is required to be issued upon the said respondents. The petitioner is however directed to take steps for issue of notice upon the respondent number 4. Steps to be taken. a notice to be issued, returnable within 2 weeks. Place the matter thereafter.
Duly obliged. Thank you.
Much obliged.
Yes.
Daily cost list item number 1.
My lord, this is the matter relating to the appointment of the agent by the Gentile Hill District Council. If lordship mindly peruse the first and second last order. In the last order, my learned friend sought time to settle the dispute, to settle the contract with the writ petitioner. What happened, my lord, thereafter? He was summoned, she was summoned number of times. And what they are offering is, my lord, I'll place on record. First, they say that they cannot give they settle the contract with the petitioner. Petitioner replied that I am the tenderer, and the successful tenderer requires to be settled with me. They say, no, you propose another third person, bring third person, we will appoint him and we will run together. I say, how can we do that? That is in total violation of the NIT provision. Second option they offer, they said in that case, you shift it from Mokuntur to Clerency, then we will appoint somebody and collectively 3, writ petitioner, district council and third person will run together. That was the other options. The writ petitioner say that it cannot be done in that way. That they say that please let us share 50-50%. Share should be there. Then in that case, we are ready to settle the contract with the petitioner.
Where are the terms of all those things? You are saying where are those?
Well, nothing is there. Nothing is there. How they are
if you see the last part, it is for you.
My lord,
yes.
My lord, we
you
made
that it was your submission that we are
trying to settle it, my lord. And for that purpose, it appears that they were called, my lord. A series of meetings were held because when it comes to settlement, my lord, it cannot be in terms of NIT, my lord. Settlement will be something give and take, my lord.
No, then matter will be decided on merit.
Matter can be decided on merit, my lord.
If that be the thing, because I probably, so far as
my lord,
what is reflected from here is that the matter was not taken up on your submission, that there is a likelihood of influence. So if you are putting all those preconditions, it means like there is no settlement.
Yes.
My lord, settlement, as the word itself, my lord, there will be some give and some take.
It cannot be.
If they want a full settlement of the gate, my lord, that is to come from this honorable court, my lord.
So whatever the case, pursuant to this previous order, some steps have been taken.
They were called, my lord.
They were called. Some negotiation has taken place, which is not agreeable to the petitioner.
Well, because the settlement framework should be done within the terms and conditions of the NIT. Suppose if I settle with the council, another tenderers will definitely come and challenge that there is in violation of the NIT. They are settling, hobnobbing with each other and settle the matter. The entire settlement will become illegal again. So we cannot do that. So I say therefore, for district council, settlement purpose you call for is to settle the matter under the framework of the NIT. For that we are ready to run in full cooperation with the council. But their settlement meaning is completely different. Give and take 50-50, bring another third person. We don't want to see the face of the retaliant. Third person you bring it. This cannot be, my lord. So if they are not, Lord should allow me to advance my argument. I'll place my case.
Where is the scope for settlement also?
Well, here is what happened, my lord. My lord, this is pertaining to a check gate settled by Gentile District Council, my lord. So, my lord, tender was issued. The respondent was one of the participants and she was the successful bidder, my lord. What transpired, my lord, the land offered by her was not suitable for setting up the check gate because that will cause a lot of traffic disturbance, my lord. So we decided to settle it in favor of the second lowest bidder, my lord, which she came and challenged before this honorable court because the land offered by second lowest bidder was more suitable for the purpose, my lord. Because it is on the highway and the other matter is pending before lordship that on national highway check gates cannot be set up, my lord. So that being the case, they challenged before this honorable court in first round of litigation, then in second round of litigation, finally this honorable court came to a conclusion. In the meantime, what we have done, my lord, we have started running it departmentally. We have neither given to the respondent nor to the L2, my lord. And we have taken a new land, my lord.
Respondent or appellant?
Here, sorry, my lord, the appellant, my lord.
Well, what exactly happened? Short in 1 minute.
I can just complete the facts. So what happened, my lord? The district council took a decision that we will run it departmentally and altogether in a new place, my lord. The tender was issued for Mukundur, my lord. which is on highway. Now district council has leased a land in the name of district council, my lord, in Clear Tirsi. That is where the Joy bypass starts, my lord. It's a big land, and we are running the check-gate now departmentally ourselves, my lord. She has come. Appellant's
You are
interest is,
offering the appellant that to run that we bridge. Is it we bridge or check gate?
It's a check case. My lord, what exactly happened is this: NIT issued 11 candidates bid for the process. Out of 11, my lord, 2 successfully declared as a successful bidders. I was declared as the first bidder. Second bidder was there. Now the first and second bidder we offer in the Muguntur. I offer in the left side. Another second bidder offer in the right side. Same highway. Now tender committee comprising of the expert committee visited the spot, analyzed the situation, traffic situation, all the feasibilities. They say that yes, with the appellant, my client, offer is suitable. They selected. They recommended for them. Now the district council now, without any authority now, they jump into, they say that no, we cannot give to you, we will give to the second one. So they settled the contract with the second person. I challenged that contract before this honorable court. This honorable court set aside that one, that you cannot do this. You cannot do this. So while settling the check gates.
So the contract was confirmed with you?
Yeah, my lord. It was not yet. The contract confirmed to the second bidder was set aside by the learned single bench of this court, and directed the district council that when you settle the settlement, the contract, you consider the proper aspects of the matter and in accordance with law, settle it. The issue NIT is there. NIT was never intervened. Now the district council sat together and they said, yes, you are the first bidder. Therefore, we selected you. They offer appointment letter. You provide the proper plot, and we will give the contract to you. Now they say that since your side, the land offered by you, my lord, why don't you give it to other side, the right side, which was offered by the second bidder, set aside by this own court. So on the advice of this council, this is she obtained the petition, obtained the list, and offer. I'm ready that one also. Now instead of settling it immediately, my lord, before signing the contract, they shifted from Muguntur to Kalirinchi, 5 kilometers away, and settled to another failed candidates. And they claim that it is departmentally run. No, they appointed third person, failed candidates, and run the thing. Therefore, that was taken place. And the matter came up, and the learned single bench entirely agree with the contention of the appellants here, that the action of the shifting is illegal, acting of it is discrimination, biasness is there, that is a violation of NIT. However, I did not challenge the shifting and the appointment of the third person, who is running department, running in the Kalirinchi. So in view of that, High Court could not entertain the grant relief. However, impose exemplary cost to the district council, fact, 2 lakhs. District council was happy enough to accept that one. Being aggrieved with this, I approached before this honorable court. And when we moved the matter, Lordship Justice Padachachi was one of the member. This honorable court came down heavily, that if you settle with another third person, that is worse again. So take corrective measures, so and come up. Lordship order is very clear. Now, after 2 weeks, the matter came up. They said that they nullified the appointment given to third failed candidates. And now departmentally we are running, and we are making an effort to settle the contract with the appellant here. Give me some time. So on his request, time was given, and I was cooperating. And the way the offer is, we can. So
at this stage, you find that there is no scope for.
From my side, there is no scope. I cannot settle the contract outside the NIT terms and conditions. Lordship, hear me.
So we'll record that there's the negotiation has failed, and matter to proceed on merits.
I'm ready to advance my argument also. I'll take short time only. It's a 2021 NIT matter pending for long. Short issue.
You are successful in avoiding the bench.
Yes, exactly. There was a successful bench hunting.
You offered the same land, isn't it? The land which you wanted, the initial settlement.
Well, here what happened?
Now, after he offered the same land again, then you again reject.
Yes, and there is a traffic jam. When
if I may place this in correct perspective, my lord, the L2 bidder, the land offered by L2 bidder, same land has been offered by L1 bidder.
On his advice.
That is what he has done it later.
My lord, there is every chance of litigation between the L1 and L2, my lord. Same land, my lord.
Okay. The lease was there.
Same land, my lord.
And that is not the ground. Might just Your Lordship allow me to proceed either today or this week itself.
We'll take out the matter for hearing.
Just I think first the NIT with Lordship permission.
We'll do the hearing today itself.
For me, I'm the subject to Lordship convenience.
We are here.
My lord, I am a pledge, my lord. The NIT is page number 57, my lord.
We can take it up tomorrow, my lord. I didn't think that it will be taken up today for hearing.
Not tomorrow. If the matter is taken out, it will be taken out up to 1 week.
Tomorrow.
But Mr. H.L. Sangresu, Learned Senior Counsel, appearing for the appellant, who has submitted that on the strength of this court's order dated 30/10/2023, the respondent, Jante Hills Autonomous District Council, JJDC, had invited the appellant for settlement, for talks for a possible settlement of the issue amicably. However, it transpired that in the meeting nothing substantial could be agreed upon, and in essence the negotiation or talks of settlement has broken down. Accordingly, the Learned Senior Counsel has submitted that this matter may be heard on merit. In view of the submission made, the matter will now be heard on merit. As prayed for by parties, this is matter to 1 week.
Item number 2.
There's nothing like avoiding bench, my lord. In fact, on the last date, I was ready to argue the matter.
See,
the court was not.
Submission, if you go by your submission, it is your submission that it isn't recorded. There is every likelihood of it.
My lord.
Exactly.
The impression created was that whatever mistake is there on your part would be corrected.
Exactly.
But then that has not been done.
Right.
That is what this impression, this basically I am getting subject to lordships.
But I use the word settlement. Settlement. If we exceed to fully, my lord, what they are asking, that is not a settlement.
Sorry to say this.
So, like a fair approach to litigation is always appreciable.
My lord, I meant by settlement, my lord, some give and some take, my lord. I didn't mean, my lord, while submitting that, whatever the respondent.
But whatever the case, you see, if say settlement has to be mutually agreed upon by the both parties, if it is not so, then
it is not mutually agreeable.
And the terms and conditions are there laid out in the NIT itself for settlement of.
I'll only place the facts, my lord. Now, draw the inference.
Even then, in spite of that, if you still feel that you can, reach out to the appellant, bring out a settlement, you can do so.
But we have tried, my lord. There are political angles to all this, my lord. It's not going to work out.
Exactly.
The appellant belongs to an opponent political party, my lord. The ruling dispensation is different, my lord. There are many angles to all this.
Always there in this kind of matter. It's always there. We will go by law.
Yes. Thank you.
I do.
It's a more of ego, my lord, than contract, my lord.
Item number 2.
Yes.
My lord, we have come against the judgment and order of the learned single judge, my lord, dated 1/12/22, my lord. My lord, here what happened?
Where is the impugned judgment?
Impugned judgment, my lord.
Yes.
May I place the facts in brief, my lord? The very brief facts, my lord, here. But here, my lord, the appellant is called NILIT, my lord, National Institute of Electronics. They impart computer training. Earlier it was called DOECC Society, my lord. Now, this organization has headquarters in Delhi, my lord, and it has branch offices all across the country, mostly in capital cities, my lord. So it has offices in Shillong, Mizoram, and here what happened, my lord? An advertisement was issued by NILIT Aizol Center, my lord, in the year 2009. For several posts, my lord, one of the posts included a particular post where against which he applied for, my lord. My lord, that was the period, my lord, when NILIT was opening centers all across the country. But this was the initial phase of NILIT, my lord. So at that point of time, Aizol did not have a center, my lord. So what they did, they transferred certain posts from different centers, my lord. 1 or 2 posts from Calcutta, 1 or 2 posts from other centers, and set up a new center there. Only posts were transferred, vacant posts were transferred, my lord. And when the posts were transferred and NILIT Aizol Center was created, my lord, a direction was issued from the headquarters, because every center has a director, my lord, center head or a director, my lord, to fill up those posts on temporary basis, my lord, and adhere to the recruitment rules. So the recruitment requirements, my lord, the qualifications should be prescribed as per the rules of NILIT, my lord. And second requirement was that fill up the post on temporary basis, because eventually this post will be transferred to Itanagar, my lord, because that was the initial phase, my lord.
All the posts. All the posts.
Yes, my lord.
Not only the petitioner.
My lord.
And that direction was issued prior to the issuance of the advertisement.
Prior to the issuance. When the center was constituted at that time itself.
That has happened which year? The advertisement is of which year?
Advertisement of 2009, my lord.
And now we are in which year? In 2023. Now did you cancel that advertisement?
Well,
have you?
But
have you?
No, but there are some few more facts, my lord. I'll just then, my lord, only 2 or 3.
You say, like, do not make it unnecessary, and you may not have to dwell on those facts by which you say, like, which should not have any bearing. You see?
No, I'll only state the necessary facts, my lord. So, my lord, advertisement was issued. Our case is that advertisement was issued in total defiance of the directions issued by the headquarters, my lord. My lord, advertisement is not on record, my lord. And even before the learned single judge, the actual advertisement, I think, is not on record.
What? But I prepared
68.
68.
This is the average.
And I prepared this just a sort of synopsis, facts, dates, my lord.
Now, so far as the recording of facts by the single bench,
No,
there is nothing wrong in it.
No, my lord.
So we can.
My lord.
It's a if you basically place the same thing again, what use it would have? This is you are talking about the rule, or this is advertisement.
This is the dates, my lord, relevant dates. This is a sort of synopsis, my lord, for convenience of your lordship, my lord. So, my lord, the recruitment rules prescribed, my lord, that qualification of first class BE, recognized equivalent qualification with not less than 65% marks, or M.Tech or ME or M Design or PhD, my lord. When the advertisement was issued, my lord, even MSc was included as one of the qualification, my lord, which is not as per the rules, my lord. And the respondent herein only has MSc degree, my lord. Till today, he does not have BTech or MTech or the essential qualification which were as per the rules, my lord. That was one aspect, my lord. And second aspect was, my lord, the post was advertised on regular basis, my lord. But while giving the appointment letter clearly says that the appointment is on contract basis, my lord. And he accepted that appointment, my lord. Then after serving for 11-12 years, my lord, he came before this honorable court seeking sort of regularization of his service, my lord. This honorable court, referring to one of the decision, my lord, passed by Arunachal Pradesh bench of Itanagar bench of Guwahati High Court, my lord. In that case, my lord, what happened, from the same set of people who were appointed, my lord, against the same advertisement, those people, two of them, my lord, they were meeting the eligibility requirement laid down in the advertisement, my lord, in the rules. Whereas the respondent, till today, my lord, he is not BTech or MTech, he is only MSc in computer science, my lord.
So those people, they were having
the requisite qualification.
So for them, it was not a contractual appointment.
But initially for them was,
supposing if your initial instruction,
my lord,
was to issue advertisement for appointment on contractual basis. So just because those people, they have requisite qualification, for them this advertisement became a advertisement for a permanent thing.
No, my lord. They went to the Honorable Guwahati High Court, Itanagar bench, my lord. Itanagar bench gave a direction to regularize them, my lord.
So you have accepted the decision?
We accepted that decision. We did not file appeal against that because they were meeting the eligibility requirement, my lord. Relying on the decision of the Guwahati High Court, my lord, the respondent herein filed this presented petition before this honorable court, my lord, because he is now posted in Nilit Shillong Center, my lord.
But come back to the advertisement. Where is the advertisement?
My lord. Page 66, my lord. Well, this is not a complete advertisement, my lord. This is a sort of.
Where is the qualification?
Well, a complete advertisement, if your lordship permits me. I think you can have a copy of this.
Yeah.
And this is not disputed. Not disputed.
I have put it in the read petition.
That is not appended with the read petition.
It was not appended.
My lord,
the appended only
has been appended, but
short advertisement.
Qualification or details of the qualification not there. But I have mentioned in the body of the read petition.
Because what is material is this. You see, what is there in the advertisement, the qualification prescribed.
My lord.
That would be material, as far as the case of the respondent is concerned. So,
advertisement, your lordship will see. At serial number 2, my lord, this is the relevant post, my lord. Name of position, scientist, engineer C. Educational qualification experience, BE, BTech, MSc, my lord.
Yes.
So advertisement.
The respondent fits this
Yes,
criteria.
my lord. Respondent is MSc, my lord. But my lord, the difficulty, my lord, this
You say
advertisement.
that this is not as per your rules.
This is not as per our rules, my lord.
That then you have to have you issued a corrigendum. Have you modified the advertisement?
My lord, here the difficulty, my lord, one particular officer.
You have gone ahead with the selection process.
My lord.
So,
but if I may just correlate that with the rules, my lord, page 69 is the rules, my lord.
Yes, please continue.
Page 69 is the rules, my lord. Page 69. And the second one, my lord, group A2. Lords have seen that?
Yes.
First class BE recognized equivalent qualification, or MTech or ME or M design or PhD. MSc is not prescribed as one of the qualifications in the rules, my lord. My lord, because MSc is a qualification lesser than MTech, my lord.
But then why he was taken into service then?
My lord, that
why
is.
you have allowed him to continue for so many years?
But we have allowed him to continue on contractual basis, my lord.
So for contractual basis, that qualification is not essential.
But that is essential, but since some mistake has happened on the part of one particular center
So
of.
you would not mind him continue on contractual basis, but then you do not want him to become permanent. Is there your submission? That for permanency, you need requisite qualification, for contractual, no requisite qualification.
My lord,
we are getting that thing from your submission. Because every time you say that, you say like they were continued, the others were.
I'll take your lordship to I'll take your lordship to the appointment order, my lord. Your lordships, if I may, your lordship to the appointment order, my lord. Appointment order.
No, it will be appointment order for what purpose you want to take us to appointment order?
Appointment order.
Appointment order clearly says that he will be appointed on contract basis.
It will override the conditions stipulated in the advertisement. We'll go by what?
My lord, our case is, my lord, subject to your lordship's acceptance, my lord.
We are hearing from a senior counsel. We would definitely like to get the correct position. It should not be something that you just stand up and say anything you want for defending your case. Just remember what status you are carrying with you. And you will place us before us the correct position.
My lord.
My
lordship is getting some kind of adverse view because of item number 1, my lord.
At least before this bench, you have to. You are not there to play with the situation.
My lord, why lordship is getting that kind of impression, my lord? This is the first time happening in my 20 years of practice, my lord.
Definitely, you will go by law. You see, it is not that the department asks you to say anything, you go and stand up and say.
My lord, I am only presenting what is there on record, my lord. That advertisement said like this, my lord. Advertisement said like this, appointment order was issued like this, my lord. Our case is that NILIT is a large organization headquartered in Delhi. Now, one branch or one office of NILIT, my lord, committed some error, my lord. Whether we are bound by that, my lord. That is our case, my lord.
Can you, by making an advertisement,
my lord,
can you mislead the candidates, those who are holding some permanent position somewhere else, to give up their job and join your temporary job? Subsequently, by issuing appointment order, you make this regular.
But he joined, my lord. That is our case, my lord. He joined the post on contract, my lord.
But then he left that job. He was holding a regular post. And just because this is because of your advertisement, who will take the responsibility?
My lord, the appointment order was issued in 2010, my lord. Appointment order was issued in 2010, my lord. He should have raised any challenge to that at that point of time, my lord.
He may be late in challenging you. But then which way your advertisement, stipulation of the advertisement get these things? And subsequently, as my lord has already pointed out, you have not issued any Korean jump, nothing.
Korean we have not issued.
You have, see, basically your submission is going one way and your conduct is totally different.
Department's conduct.
Now, have you taken any?
Department's conduct. Not against you personally.
Don't take it that way. This court. See, your action. If you see your action and your conduct, they are not matching. They are not moving. You talk about this advertisement. Just tell us what action you have taken. Department will tell you.
But some action we have taken against the person.
What action? Tell us. You said do not go by some action. Tell us what you have done. Tell us specifically what you have done.
No concrete action. Some so-called notice was issued
to
me.
If you say even something, not even concrete, some action, tell us what.
In our affidavit, you stated, I'll just point that out.
Till you see, just take into consideration one thing that from advertisement, 13 years have lapsed already.
It seems no action has been taken against the person.
So that is what. So your submission was wrong. You said initially, Dr. Mojiga, you see, we understand what department does, but then we do not want you to become a puppet in the hand of the department. Honestly.
Something, my lord, it was argued almost, but something was there, my lord. I'm not able to point out right now, my lord.
It's all right then.
But I think I'll be able to point out something in that
See,
video.
there is nothing, whatever is falling from this court is not directly against you personally. But then, say supposing something, if you add something in the courtroom and you do something else, definitely we'll take this kind of case. Probably in certain matters, even the court should award cost also. You see, like for, like subjecting the employees to litigation, unnecessary litigation.
So what do you want to do now?
My lord, that is the entire case, my lord. I don't have any more case than that. Our only case, my lord, that advertisement was issued in deviation of the directions, my lord. But if I may just point out the direction which was issued by the headquarter, my lord.
It was issued by the then director, isn't it?
Then director, my lord.
Now, where is he now?
But I do not know. I don't have instruction whether he is still in service or he is retired, my lord. Quite possible that he is retired.
Was any action contemplated against him?
Nothing has been done. Anyway, that's beside the point. We understand your case. You say that the advertisement was floated. The advertisement was floated, which is contrary to the rules. So it is because of it. But it is your own fault. It is your department's fault that situation has been created. Now you cannot blame the respondent for responding to the advertisement on him being, having the requisite qualification as portrayed in the advertisement.
But our case is slightly different, my lord. But may I point out the advertisement also, my lord? It says, my lord. Lord, so kindly see the advertisement, my lord. first line, my lord, in the advertisement.
Yes.
DOEACC Society Aizol Center invites application from qualified professionals of Indian nationals for filling up various posts on regular deputation basis, including permanent absorption basis.
Yes. So,
My lord, it says regular public deputation, including permanent absorption basis. Whereas the direction that was issued to the my lord for filling up the post, it clearly stipulated, my lord, that page 180, my lord. Page 180, my lord.
yes.
This is dated 10 December 2009, office order. With the approval of the competent authority, the following revived posts at DOCC Center, Tezpur, Kolkata and Aurangabad are transferred to DOCC Center Aizol on temporary basis with immediate effect. Serial number 2 is, my lord, that particular post, my lord.
Yes.
And this post was transferred from Tezpur, my lord, this particular post. Para 2, it says, my lord, these posts are to be filled up on temporarily on short-term contract basis as per requirement in accordance with the approved recruitment rules and service rules of DOCC Society. The above 5 posts are being transferred temporarily to Aizol Center, as this post would be transferred to Itanagar Arunachal Pradesh Center as and when required. So the other things may not be relevant, my lord.
Have you ever communicated this copy of the office order to the respondent to justify their extension of things? Have you ever said that your claim for regularization cannot be entertained because of these things and all? Have you ever been communicated, or just immediately after his recruitment also, appointment also? Did you communicate this copy of the order to them?
My lord, that question did not arise, my lord, because if Lordship kindly sees the appointment order, my lord, page 73. The first initial appointment order that was issued to him.
Then what about the stipulation of the advertisement?
But he accepted, my lord. But
Accepted advertisement or the appointment?
appointment, my lord.
And what about the advertisement?
But that is our
Now,
case.
your advertisement you are not accepting.
The page 73, Lord, so kindly turns to the appointment, my lord. Page 73. Para 1 minute. This offer of appointment is on short-term contract basis for a period of 5 years with effect from the date of your joining the post of DOCC Society Aizol Center, which is transferable to DOCC Society Itanagar Center, Arunachal Pradesh, as and when required. The appointment will automatically cease on completion of the term contract period, if not extended. However, the contract can be further extended based on your performance.
Yes. But then it doesn't say that it is subject to the acquiring qualification or no qualification.
No, my lord.
So that means that your argument with regard to qualification will not stand. We'll go by the stipulation made here. Your extension was subject to the satisfactory performance, nothing else.
My lord, the difficulty, my lord, even this appointment order is issued by Aizol Center, my lord, not by the Nilit headquarter, my lord.
But then you have not done anything to cancel this thing, recall this thing. This stands as it is. And you want the court's order to do everything. It cannot be. These are all your department election. You could have corrected it.
That's true. I know, my lord. It's not a. But I'm simply because only point for consideration, my lord. As far as I am concerned, my lord.
You would not have done anything had there been no approach by the respondent for this thing with the fear of getting himself regularized. If the respondent had not approached the court, you would have kept it like this thing. You would have been happy to continue the situation like this.
Even he was happy, my lord, for 12 years.
He's happy, but then you see your employer. You see, he was happy for 12 years and then he became unhappy. That is why he came here. Okay.
Anything else?
This is where some stuff should be.
That is our case, my brief. Our only case is, my lord, till date he does not meet the requisite qualification, my lord. Till date he is not MTech, my lord, or BTech. Till date he is MSc. So in these circumstances, my lord, whether...
Now what happens if you allow the appeal and if his petition is rejected, the service will be terminated, or you will retain him?
My lord, there was no proposal to terminate his service, my lord.
So there the qualification will not be this thing. If you want, it continues in this capacity. Qualification will not come into play.
As far as temporary contractual, my lord, maybe there is...
Qualification can be relaxed from the rules. The rule has that stipulation.
It does not.
Which way to take your submission? That qualification is a must. It is not must. It can be relaxed depending on the status of the employee. You can take it that way also. You can record it that way also. But then you will not be happy if we take it.
That is our only point, my lord.
Sometimes
we could not regularize, my lord.
Section of the departments are such. You see, where you feel like avoiding some cost. That is,
my lord, you're also already granting relief, so at least costs. I think these would be...
See, you cannot subject. You cannot just, this is unnecessary litigation.
Yes, Mr. Sen, do we have to see?
Yes, if he has finished, my lord. Bill. Can I win?
Dr. Mujika, would you point out anything so far as the single bench judgment that has not been write out, but then read out? Will you show what is the illegal part or what is the illegality in that thing before Mr. Sen?
Because you have a seal.
Just pinpoint to.
In the first instance, I have asked you this question. What, to read out the...
My lord, the learned single judge has directed, my lord, to consider para 13 of the judgment, my lord. In view of the facts and circumstances of the case, the respondents are therefore directed to consider the case of the petitioner for treating his appointment to the post of scientist C. in a substantive permanent capacity with effect from 8/10/2010, the date the petitioner joined pursuant to offer of appointment dated so and so. My lord, our only case is, my lord, he cannot be treated as permanent because he does not meet the educational
qualification. To the
qualification.
observations and the reasoning of the single bench. Which part you would point out is not in accordance with law?
This is what I was telling you. All relatable to the advertisement.
Under para 12, my lord, the learned single judge held that it is too late in the day for us to contend that, my lord.
Definitely, 13 years is from.
Lots is observed. We should have recalled his appointment that point of time.
No, you have not done anything.
We have not done anything.
See, whether your recalling would have been correct in law or not, but then they would have given a cause of action for him. But you have not done that also. We are happy to continue with the situation.
Some actions should have been taken by the department that point of time.
Just remember that you are the authority. Okay, you have the authority to pass order, modify it and all. The employee is not. So you cannot equate yourself, your action and his action. He cannot correct.
That's true, my lord. No action was taken.
In any case,
when it came to the knowledge of even for the headquarters that a wrong appointment has been made, my lord, though there is no pleading when it came to their notice for the first time, my lord. But then also no action was taken.
In any case, you see, with the passage of time, the respondent in any case would be entitled to equitable relief.
Our only case, my lord, till date he does not have the prescribed qualification. That is our only case, my lord.
But as my brother has pointed out, see, that has not also been pointed out in your appointment order, that you have to get yourself qualified within such and such a time.
That's true, my lord. This was raised for the first time when he approached for, or when he approached this honourable court for regularization, my lord. This was
raised. You raised the question of qualification. Why you have retained him in service?
That's true, my lord.
Why you have taken him in service?
I have no answer to that, my lord.
If you do not have the answer, then see if there is basic answer is not there.
He was retained, my lord. He was retained. But that is only for your lordship's consideration whether that will create some right in his favor, my lord, because we did not take any action.
Not clear. This is the crux of the issue. And you see, like you have not brought on anything to show that there was never any effort by the department to correct this advertisement, to recall this thing, as my lord had initially pointed out. You have not issued any corrigendum and all those things. Nothing. So
actually, what happened?
If you have not done it there, can you take that stand here?
Actually, what happened, my lord? He was appointed in Aizawl, then he was transferred to Itanagar, my lord. From Itanagar, he's been transferred to Shillong. So he has been within the jurisdiction of many offices, my lord.
Departmental action is not subject to his transfer. He may keep on rotating. Your instruction is 2009, advertisement in 2010, and that also has been issued by the responsible officer, director, advertisement. Thereafter also what you have done, we do.
Director
we have been kept in dark with regard
director of that center, man, Aizawl center. No,
we have
not
been kept in dark. Probably you want some order from this court so that you can make the employees suffer, nothing else. And it's on record that you have accepted the judgment of the Guwahati High Court.
My lord.
That has
we have accepted.
See, that stand with regard to the temporary contractual appointment, and that was there. Okay, so far as that point is concerned, you see, there is nothing. Even the single judge also has accepted that. There is nothing to show that, you see, like it appears to be disagreed. Only stands your qualification. Nothing more is there. Nothing more is there.
Nothing more is there.
Yes, Mr. Sen.
Yes. Great, please, your lordships. My lord, basically two issues were raised here. One issue, my lord, I'll go issue wise, my lord. One issue he argued for quite some time, my lord, that though there was a instruction, my lord, from the headquarters that these posts which were transferred, my lord, temporarily pulled in Aizawl, my lord, from other places they were brought and temporarily pulled in Aizawl, were ultimately to be transferred to Itanagar. And there was a direction these posts should be filled up temporarily, but not on regular basis. That's what is his contention, my lord. I'll take my lord to that particular document, your lordships. That is at page, my lord, type copy is at page 126. My lord, this is dated 10 December. Lordship will take note of this date. 10 December 2009.
Yes.
Now you say, with the approval of the competent authority, the following revived post of DOI, at that point of time it was known by this name, my lord, Tejpur, Calcutta, Aurangabad, are transferred to the DOI Center, Aizawl, on temporary basis with immediate effect. So, my lord, two things are here. These are a regular post, but temporarily pulled in Aizawl. So, my lord, these posts were named 1, 2, 3, 4, my lord. Altogether, 5 posts were there. Now, my lord, the senior system analysis, that is scientist C. These are also called scientist C. 1 and 2, serial number 1 and 2, my lord. These are scientist C. Others are scientist B. They are also called scientist B, my lord. Now, the direction is here. These posts are to be filled up temporarily on short-term contract basis as per the requirement in accordance with the approved recruitment rules of the service rules of the DOIC Society. The above 5 posts are being transferred temporarily to Aizawl Center, as this post would be transferred to Itanagar. So there was a clear direction. There is no denial. Now, lordship has seen the date 10 December 2009. Now, my lord, these society, how they function, they have their internal set of rules. Now, I have annexed these rules. My learned friend has never referred to the rules. Well, this rule is at
69, page 69.
But it is also in the legible copy, your lordship, 63 also. And it's very legible. Now, this date, my lord, you'll see. December 2008, 2009. Now, before this date, my lord, just apprising this court, before these days, what was the practice? All appointments were made on temporary basis or on deputation. All appointments. There was no rule for regular appointment. The thing has changed, game has changed after this notification.
Yes.
So this is after this notification, my lord. Now your lordship will come to the bottom. What are the changes they brought about? 3.1. Now 3.1, prior to amendment, I read it. All appointments will be made either on contract or on deputation basis only for a period of 5 years against sanction post on graded scale pay. On completion, the period of contract can further be extended based on the performance. Cases of renewal of contract shall be considered on the recommendation of the concerned head office center. So it was an admitted position. Well, till this notification, all appointments against the sanction post only could be made by contractual appointments, not on regular or on deputation. But this has been changed, my lord. Now, what is the change, your lordship? 3.1, appointment. All appointment will be made either by direct recruitment on regular basis or deputation, including permanent observation. Now they switched over to regular appointment. Now, what is the date? 8/2009. Now, my lord, when this, what I have referred to just now, your lordships, at page 26, 126. Now, 126, that was issued on 10 December 2009. Most probably, my lord, they were not aware about the amendments. And when this advertisement was issued, your lordship, it is in February, 25th February, my lord, 2010. After this amendment, the person who issued, he was conscious about it, that we cannot go for temporary. We have to go by the rules which has been amended. So very correctly, that advertisement has been regular. Now, my lord, there is nothing wrong. Now, coming to the second point, how casual they are, I'll point out. Lordship, I'll again take my lord.
Advertisement has never been recalled.
Never.
Advertisement never been.
No, but then even what he is saying also incorrect, my lord.
It stands.
Exactly,
It stands.
it stands. What he is saying otherwise also, my lord, is not correct. That's what I am showing, my lord. There is a rule, as per the rule, you have to go for regular appointment. There is no scope. A mere communication, fill up this post on contractual basis, when the rules say otherwise, my lord, obviously rule will prevail, not those instruction issued in the form of a communication. Cannot be. So what I am saying, your lordships, amendment came. After the amendment, this instruction should not have been issued. Anyway, they have issued. But the advertisement which was made after the amendment, very correctly made. Very correctly made. Another thing I am coming on, that will clinch the entire issue. So for this particular issue raised by my learned friend, can I take my lord to 126? Now these were the 5 posts. Now these 5 posts were also advertised. This is not, no dispute in the bar that these 5 posts were not advertised. My lord, these 2 posts of scientist B,
yes,
as well as my lord scientist C. Scientist C is a higher post, which were temporarily polled to Aizawl, were advertised. If I can take my lord to the advertisement, 129, page 129, the type copy. Lordship has got it. 120. Yes. 120. Doig Society Aizawl Center invites application from qualified professionals of the Indian nationals for filling up the various posts on regular deputation basis, including permanent absorption basis. No, my lord, lordship will look the tone and tenure of the advertisement. This is in uniformity with the amended rules.
It says regular deputation basis, including permanent absorption.
That is exactly.
That is regular.
No, that is, my lord, exactly the amended rule also. It can be either on regular basis or deputation absorption basis. Definitely. So what this advertisement had followed, they followed the amended rules, and they were under obligation to follow that. So there is nothing wrong, which I am putting. Next, I am kindly what they have advertised, your lordship. You kindly, your lordship, see, I am concerned with 3 and 4. Sorry, my lord, 2 and 3. Scientist, engineer C, 3 number of posts. The same thing, my lord, which were temporarily polled. 2 posts were there, Your Lordship. Now, these included 2 temporarily polled posts. I'll show it, my Lord, from subsequent communications. And Scientist B, 4 numbers. These includes those temporarily polled posts in Aizawl, which were supposed to be transferred in Itanagar. Now, my Lord, applications were filed, found suitable, called for an interview, and our case was placed before an expert committee. This has a huge bearing on this. It has gone before the expert committee. Now, these, Your Lordship, my Lord, expert committees, Lordship can kindly type copies at page 133, the minutes of the selection committee. Again. Lordship has got it. May I read it?
Yes.
The minutes of the meeting of the selection committee held on 11 June 2010 for selection of the post of scientist C senior engineer in scale of such and such. Advertisement number 2 2010, number of candidates 11, number such and such. Now Gordon Kishan, this is my respondent, Your Lordship. His name was appeared at top. Following candidates are recommended for selection. Now in the merit list, I was on the top. Now who are the expert, Lordship? Kindly take note, that will ultimately come. Below that, Your Lordship, head of the department elected NIT Silchar. They have the expertise. They know what is equivalent. They know what is MSc in computer science. I mean, as a layman, my Lord, there are decisions I'll cite. Neither the court nor the lawyer should comment on this. It has gone through the expert. They have looked into it. Now, my Lord, who are the other? Deputy General Manager, BSNL, Aizawl. Then, my Lord, Executive Director, Channel Direct Society. So, my Lord, Registrar, Mizoram University. My Lord, all these experts were sitting. They looked into my qualifications. So qualification part I'll come later. Let me get clear of this. Now, my Lord, kindly if I can take Your Lordship to the next page, 134. No, my Lord, I will not read it. This is the terms and condition my learned friend has already read. Now, Your Lordship, if I can take my Lord to page 79. Now she has got it. Now that is came from Delhi headquarters to Aizawl after the appointments were made. May 2, 2010. Transfer of post mean for Doyak Center, Itanagar regarding. Please refer to this office order, event number dated March 11, 2011, transferring 5 posts to Itanagar, which were temporarily polled at Aizawl Center, and further communication dated such as in connection with the following has been decided. Transfer of 3 incumbents appointed against the post of Scientist C. That includes me, my Lord. I'll show Your Lordship how. And Scientist B too. Along with the posts from Aizawl Center to Itanagar Center immediately. After these 2 more posts out of 5 posts with Aizawl Center need to be transferred to Itanagar Center. As earlier directed by the office order number such and such, Aizawl Center may transfer 2 vacant posts of Scientist C Itanagar Center. Since there is only 1 post of Scientist C recommended for competent authority for Itanagar Center, with the transfer of incumbent appointed to the post of Aizawl Center, the post stand fill up. As such, another incumbent appointed against Scientist C at Aizawl Center may be adjusted against the vacant post of Joint Director. Lordship will take note. Now, while transfer, this is me. Subsequent pages, my name is mentioned. This is my client, my Lord, who was appointed in Scientist C. Along with the post, the incumbent was transferred to Itanagar. And they themselves, with this post stand fill up. Now, Your Lordship will come, my Lord, most important, my Lord, page 81. Now they have effected the transfer. 30th May 2011. Page 81, my lord. Consequent upon the office order number such and such, date such and New Delhi, the three incumbents' appointment against the post of Scientist C1, Scientist B2, along with the post which were temporarily transferred to Aizol Center, are hereby transferred to Dwayak Center, Itanagar, in public interest with immediate effect. They will be relieved of their official duties with effect from joint such and such. Number 1, Gordon Kinchi Nonkendry. That's the writ petitioner respondent, my lord. Scientist C. With his post, he was transferred. Now, this is very important, 2 and 3. With these 2 and 3 went to Guwahati. They invoked the jurisdiction of Guwahati. Now, these 2 and 3, my lord, Scientist B. These are the same, similar posts, temporarily pulled. Now, what my learned friend is complaining. Now, these people, they file a writ petition. I have collected even an affidavit, same respondents were parties. Is it not misleading the court? Not a whisper. Lordship will go through the judgment. Only 2 contentions were raised. One contention correctly, which my learned friend has conversed. Having accepted a contractual agreement, they should not have challenged it. This is the only thing. I'll answer that. There are decisions of Supreme Court. That contention was rejected. But they never raised that there was a direction it should be temporarily. That was violated. I have not annexed the affidavit, my lord. I got a copy of the affidavit.
So that stand which they have taken here.
New stand. Where from they got it?
Not there.
Something concocted, made out, misleading, I will say. They have gone to that extent. They should have raised it there.
That was not your plea, Mr. Dr. Majid.
So those two. Before this honorable court, in our affidavit, that is our plea.
You have never raised.
No, the
That
two,
is there, it may not be applicable.
the two person who have approached the Guwahati High Court were similarly situated with the.
Only thing they were scientists. B.
Different
So far their post is concerned, what he is reading first contention I am answering, my lord. Their post also temporarily pulled in Aizol, and there was a direction not to fill up regular basis.
Emanating out of the same advertisement.
Yes, same. Everything.
Advertisement.
Same. So in their case, they have never raised.
It's a cover.
And the same respondents were made parties. So, my lord, this is something, my lord, they should not have raised, my lord, without, my lord, going into the case and the stands taken by the respondents in Guwahati High Court.
Have you produced a copy of the order?
Yes. Even the single judge has relied on the judgment, heavily relied on the judgment. Heavily relied. So, my lord, these contention, my lord, the lordship need not go into it. Lordship, this is something, my lord, very casual. It in fact amounts to misleading the court. Now I will come, my lord, this is very important.
One second, just. This letter which you have pointed out just now.
Lordship.
Their signatory is registered.
Register, my lord.
You have seen that order, page 79.
79. Yes. So register, my lord. Register of the Dwayak Society, headquartered Delhi.
Now, if we go back to the letter,
Lordship,
which Dr. Majika is relying upon, laying down the condition that of appointment before the advertisement was issued, wherein it was said that post should be temporary. Dr. Majika's contention.
Lordship.
That letter is also signed by registrar. See? Then how we will stand? Just see, come back to your thing, Dr. Majika. The letter which you have pointed out.
Well,
the instruction at page, perhaps at 180 page.
180.
See who signed it.
Same person.
Registrar, same
person.
How? See why you are taking those stands? And you see, like, is there,
Anyway, so far I think this point is continued, your lordship. I think this clinched the issue, my lord. And these are admitted position, my lord. Nothing more to say. I have annexed the copy of the judgment of Guwahati High Court. Now, my lord, the second point will be very interesting. Now, what my learned friend, my lord, is not a case by lapse of time, some kind of illegality committed and the standard regularized. My lord, I did not make that submission. No irregularity there at all. What are the qualification prescribed by the rules? I have set it out, my lord. Even it was set out, my lord, in the writ appeal. Lordship can, they have quoted in the body. Lordship will kindly come to my lord page 8. Page 8 and 9.
8?
8 and 9. My lord,
8 of
9.
this
Mine, my lord.
memo of appeal.
Lordship, memo of appeal.
8. 1.7.
My lord, 1.7 relevant, my lord, in the table, my lord, that will be convenient for your lordship. Page 9 in the table, your lordships. On the left hand side, your lordships, the qualification prescribed by the rules they have set out. Just pointing out the anomalies, and on the right hand side of the table they have laid down, my lord, the qualification prescribed in the advertisement. So that will be convenient for your lordships. Page 9 in the table, your lordship. You can read it, my lord.
Yes.
The second part, first part I am not going. That temporarily I have already explained, my lord. Posts are to be filled up in accordance with the approved recruitment rules, the service rules of DOAC Society, which prescribes the qualification as follows. First class BE recognized equivalent qualification with not less than 65% marks, or MTech, ME, design, or PhD. Might not admitted, I concede. They say either it is a first class BA recognized or recognized equivalent. The equivalent has been used here. It either it's not necessarily should be ditto, my lord, B, first class B. It could be the equivalent. Now I'll come, my lord. Who determined the equivalent? We cannot determine the equivalent. Now what is prescribed in the rule? I mean, in the advertisement, my lord. On the right hand side, educational qualification and experience, BA, BTech, MSc in relevant field, or recognized equivalent qualification with not less than 65% mark, etc., etc. So these advertisements, this cannot be fatal. They have went a step forward. They have mentioned one of the equivalent, MSc, one of the equivalent in relevant field. Now what is relevant field? They have not mentioned. So far I am concerned, I am an MSc in computer science. And these all deals with, my lord, so far NELID is concerned, my lord, I have mentioned in my read petition, this deals with, my lord, human resource development in information technology. That is the prime object of this society. Now, my lord, will it be fatal? It cannot be fatal. Why, my lord? Number one, before I answer this, I'll just point out one thing very interesting. Till filing this writ petition, there was not a single communication what he canvassed before this court that you do not have a qualification. So we are accommodating you on temporary. There was no communication. I never knew that I do not have the qualification.
That is probably, that is why probably this court wanted to see the notice the signatories in that case.
Exactly.
Registrar, the signature of registrar appearing page 79 and page 180. That itself is enough that they have never raised that question, any question about your qualification.
My lord, I have pointed out this to court. When first time I was baffled, my lord, when I saw for the first time they have what they have argued, your lordship. They said we have no problem. It's absolutely covered, basically covered by Guwahati judgment. We are ready to do it. But here you have a problem. You do not have the qualification. Now after so many years. Now I made a prayer before the learned single judge, call for the records. This is something concocted in it. Call for the records, look into it. I think, my lord, that record perhaps, my lord, that order is there, record was called for. My learned friend was conducting. He was with the record, some officials were there. Then, of course, my learned friend said there is nothing on records. He doesn't have qualification. But unfortunately, I should have pursued the learned single judge recording.
Who has signed the affidavit on behalf of the...
There is, my lord, I'll come to that. This is the local director here. Now, he is the only person, my lord, he doesn't want. Now, my lord, this is something, my lord, made out just to deprive me. So, this is one thing lordship will take note. Now, coming to, my lord, the equivalent. Now, what is the law, my lord? This cannot be fatal, because if your lordship held tomorrow, then no, by lapse of time, even if you do not have a qualification, but even then, you see, you cannot be. Perhaps that will be a kind of thing, my lord, I don't know, may not be all right. I am saying I have the qualification. This is not the prescribed, but it is equivalent qualification. And equivalent has been provided in the rules, either BTech or equivalent. Now, my lord, coming to the law, my lord, I have submitted a compilation. So those will be very relevant here. Now, I have submitted a compilation, my lord. These compilations, my lord, very recent case, my lord. arising from Calcutta High Court, the diploma in yoga therapy. Now, a teacher was wanted with that qualification. Now, matter was before a selection committee. One of the person with yoga education. The person with yoga education was selected, appointed. Unsuccessful candidate, they challenged before the Calcutta High Court. Calcutta High Court said, that's not a qualification, prescribed or equivalent. Matter went to the Supreme Court. Supreme Court said, this belonged to the domain of the expert. They looked into the minutes of the experts. They noticed how it is equivalent. The experts were silent. They had not given any reason. But even then the courts, even though no reason is given, but it has gone through the expert. We should not touch. Well, I'll rely on that judgment. If Lordship has the compilation. Compilation is there.
What is the case?
Cases, my lord. My lord, I'll start, my lord, that expert thing, my lord. Expert thing, if we can start, my lord, that landmark judgment of the full bench. The compilation I have given, your lordship. First judgment I am referred to, my lord, 1965, SSC 491, page 8, para 12. And this is my... That is in the academic matter, what belongs to the expert, court should not go.
That is well settled.
12, my lord. Page 8, paragraph 12.
We have no confusion with regard to that.
My lord, I think I do not trouble you.
Even if we ask about, forget about this thing, if we ask Dr. Mojika to tell us what would be equivalent qualification, it would be difficult for him to say.
He says just less than. We should not utter those things, my lord. This belong to, I have seen, expert had recommended and where my name appeared on the top. Can we imagine, my lord, just before the expert, they looked into MSc, and though it is not a full evaluation, they recommended me?
My lord, experts examined on the basis of advertisement, which included MSc, my lord. The experts have nowhere said that it is equivalent, my lord.
Expert will examine only the competency of the
Actually,
candidate.
overall competence, my lord. It's not the qualification.
My lord. Experts examined, my lord, on the basis of advertisement. Advertisement included MSc, my lord. Rightly, wrongly. But to say, my lord, that experts have examined the equivalence, my lord, in my humble submission, that's not correct, my lord.
I'll read that. I'll say it.
Experts have examined because the advertisement itself said MSc, and he is MSc. There is no denying the fact, my lord. There is no dispute that he is not MSc.
No, wherefore my learned friend has the expertise that MSc is not equivalent. He is virtually one to override the decision of the experts.
But that is not the decision. My case is that is not the decision of experts that it is equivalent. Experts said that he is MSc, so there is no question of getting where is the requirement of equivalence, my lord. In my humble submission,
let me complete it, my lord. There are other things also, my lord. I am yet to disclose. I'll disclose other things. I'll disclose, my lord. Now, my lord, I will not trouble your lordship. I think that paragraph 12, lordships are away, my lord. That was a full bench judgment of the Supreme Court. We say expert domain, nobody will get into it. So, my lord, I am not troubled. Now, my lord, other decision is, but I don't think your lordship will go into it. What he is saying, having accepted a contractual appointment, now you cannot challenge it. Now, that he raised, my lord, other cases, the same respondent raised this contention, my lord, before the Guwahati High Court. That was rejected. Now, what basis? I just did some research, my lord. Normally, if your lordship go into Uma Devi, now Uma Devi says you cannot have expectation. Having accepted something, you cannot challenge it. The Uma Devi is in relation to, my lord, casual workers, not sanctioned post. Now, with regard to sanctioned post, that has been decided by the Supreme Court, my lord. That decision, they said yes. Even after accepting a contractual appointment, that can be challenged. That unequal bargaining. That proposition of unequal bargaining has been elaborated in that judgment. That is, my lord, 1986, 3 SSC 156. Now, these will apply here if he is insisting that this issue to be decided.
Yes.
Now, this is the only leading judgment because against the sanction post, yes, even after accepting it, I challenge. Now, my lord, it's a very long judgment, your lordship. Relevant paragraph start from paragraph para 100 onwards. Now, my lord, they have discussed, my lord, the common law, what is the situation in the common law of England and all, and then ultimately they laid down the law really. Now, there what happened, your lordship, certain employees permanently appointed. Now, one of the terms and condition of their service, though it is a permanent appointment, that they can be appointed, they can be, their service can be done away with 3 months notice. That is something, my lord, do not fit into regular appointment. They have accepted their appointment. After long service, my lord, some kind of inquiry was conducted on certain allegation. Then they discontinued the allegation. Instead, they were terminated with 3 months notice. They went and challenged it. Matter traveled to the Supreme Court ultimately. Unsuccessfully, they challenged in the Calcutta High Court. Matter went to Supreme Court. Supreme Court looked into it. Supreme Court said no. Even after accepting, if it is a sanction post, it's a permanent sanction post, it can be. So that proposition has been laid down. Now, Umadevi is in a different context, my lord. They said, no, you cannot, having accepted, because that is not sanction post. Casual laborers, contractual laborers. So my humble submission, my lord, this is an issue. Otherwise also, my lord, I have said that similarly...
You are referring to paragraph?
Paragraph 100 onwards, my lord.
100 till?
So start from page 12. Page 12, my lord. This is a very long judgment.
Page 12. 96 is 100.
Yes, my lord. You start from para 100 onwards.
Onwards till go.
The rule has been struck down there even.
Not clear.
100 onwards.
Yes.
Now, my lord, because why I am saying because otherwise also, as I said, similarly situated. So far, my lord, accepting contractual appointment, challenging it again, my lord, I am similarly situated with 2 persons who invoke the jurisdiction of the Guwahati High Court. Now, there they have, my lord, they have raised this, court has rejected. And court has referred to unequal bargaining. This unequal bargaining, my lord, has been referred to in this decision, that 86 I have referred to. Though they have not quoted that decision, but they have taken it from there. See, because of the unequal bargaining, sometimes even if your condition is harsh, they are compelled to accept it. But they will not easily get another job. Those are the reasons. Now, my lord, otherwise, your lordships, I don't think, my lord, if that has been rejected, and if they were still agreed, they should have filed an appeal. They have not. They have implemented the order. And in their case, from the date of initial joining, they have been treated as permanent. From the date of initial joining. The court direction was to treat them from the date of initial joining. So I don't think they can take a different stand here. But this will lead to discrimination. And that's why I have referred to a judgment, my lord, that is my lord 2006 2 SSC State of Karnataka and others versus C. Lalita, my lord. Similarly, service matter, my lord, similarly situated. Now, in their case, they have accepted, and court has given a direction. You did not go for an appeal and implement it. In my case, though I am before this court, now you are raising this objection. Now, if it is accepted, my lord, this will lead to unequal treatment. There is in para 14, your lordship. Page starts from, my lord, 115. The decision starts. Para 29. Para 29.
Para 14 or para 29?
29, man. Huh? Para 14. Sorry, man. No, sorry. Wrong judgment. I'm sorry, your lordship. That Jayalalitha start from, my lord, 106.
No, the relevant paras.
Relevant para is 29, my lord.
113.
29. 29, my lord. I just read it at page 113. May I read it, your lordship?
Yes.
Service to jurisprudence evolved by this court from time to time postulates that all persons similarly situated should be treated similarly. Only because one person has approached the court, that would not mean that the person similarly situated should be treated differently. It is furthermore well settled the question of seniority should be governed by the rules. It may be true that this court took notice of the subsequent events, namely that In the meantime, she had also been promoted to the assistant commissioner, but these are about the facts. So this is the settled position of law. Cannot be, because here in the case, they also accepted contractual, challenged it successfully, rejected, implemented. They could, if they were so serious, they could have gone for an appeal. They had not. So I don't think my lord will take it seriously.
No, so far as that part is contractual respect is concerned. So other two persons who approached Guwahati High Court,
yes,
they are also similar.
Similar.
So
And they raised this issue. That
now
was the
they have implemented Guwahati High Court's direction.
yes, they have not gone
So
for
what
it.
is the question? Why do we?
Then I am not going. Then I am not going. I thought my lord again
Because
makes.
I do not think that they can take a stand.
Yes,
Right.
they should. But my learned friend made a very long submission on this. He has referred to the appointment order and all. This is purely
If
contractual.
he has a weak case, he will make a long submission. That is natural.
But I cannot, my lord, leave things to any chance.
That is the only point I have to argue. Available to me, my lord. If I don't say that, there is no point filing appeal also.
Now, my lord, ultimately, coming to my lord, the equivalent. Again, that matters. In the expert domain, he has not, my lord. Now, what happened regarding equivalence? Very interesting. Somehow, my lord, it has not got a place in the judgment. Because after he filed, because first time he came to know I do not have qualification from his affidavit. Records were called for, nothing on records. Something concocted, whatever it may be. I filed a rejoinder. I was compelled to file a rejoinder. In my rejoinder, I made the submission. Somehow it did not get place in the judgment. In my judgment, my lord, now what is this society, my lord? These societies are under the effective control of MeitY, my lord, Ministry of Information Technology or something, Government of India. Now, the Government of India, they have similar posts. Similar posts, my lord, scientist C, B, D, my lord, all these posts, similar pay scale, and I have categorically stated same volume of work, same nature of duties. They have a statutory rules, prescribed qualification. One of the prescribed qualification is MSc, computer science. Somehow, my lord, though I made the submission, it did not get place. I'll rely on that. This is part of the records. And they have not controverted. So normally, if we file a rejoinder making a casual statement, I have annexed the rules. If your lordship wants me, I'll take my lord to that rejoinder. If lordship wants. Because what he is saying, I don't have qualification, absolutely a lie, your lordship. It's not correct. On what basis? Only because the advertisement has mentioned one of the equivalent, that will not be fatal. But this is a equivalent qualification. So if your lordship wants me, my lord, I can take my lord to the rejoinder affidavit. With my rejoinder affidavit based on record, on the rules.
No, are you looking for a finding by this court with regard
No,
to
that's
the,
what I mean.
what would be the equivalent?
No, because what he said,
that
because
will
his
not enter
submission.
into see, so far as we do not know subject to what
No.
my lord says, so far as the question of qualification is concerned, there is nothing to show on record that has ever been raised by them, except for raising it before this court.
Yes, nothing on record.
There is nothing on record to show.
Lordship.
Now, say supposing if qualification was to be a criteria, in such a case, it should not have been taken into service and allowed to.
Exactly, but even way contractual also.
Okay, so since they have taken you in service by holding a selection process and allowed you to continue, then only thing would remain that whether it could have been a contractual appointment or something. That is what it is.
In view of the judgment also, which has been implemented by them. And other thing, but because why I am making little elaborate here, because what...
Even if they say that if you are not qualified, then in such a case, they will have to show before the court.
Exactly, that's what I'm...
MSc will not be equivalent.
Exactly. And they will have to show, my lord, that composition of experts, that expert body. Somehow, my lord, the composition is... That is the law, my lord. Once the expert, my lord, whether they cite reason or not, immaterial.
And if
Once
they say that if you do not have equivalent qualification also,
lordship, then
they should not allow you also to serve.
But that I think little risky for me. Why my lord, my lord, I am not encouraging that. That may be risky. That may be if I am not having a qualification. Because I am having a qualification. If I am not having qualification, perhaps I don't know. This matter may travel to my lord Supreme Court. One may, I am saying, my lord. Now, what will happen if I do not have a qualification? Lapse of time may not cure it. There is, but I have. That's why I am insisting. I have the qualification.
Now, why you are going into all those things? So far as we understand, as we have pointed out, that none of the finding given by the single judge could have been disclosed here. So, if that be the thing, why should you enter into?
No, because he is submitting. Because he is elaborately submitting on equivalent. He doesn't, MSc is below, where from he is saying, I don't know, without touching the selection. He could have seen that selection process was not properly constituted. That is not his case. The committee constituted all right, but what committee decided not correct. Now can he see about the decision of the expert committee? And that's why, my lord, the last decision, my lord, I'll just refer to it. In my compilation, the last decision, I'll refer to 2019.
There are two decisions, 2019 and 2020.
20 I will not refer, my lord. That is regarding alternative remedy, they have not pressed. So these normally should have gone before the CAT. But at the time of, my lord, moving the motion, this issue was raised. It was not functioning.
Single judge has dealt with that issue.
That is, so I am not, my lord, on this. But they are also not raising. 2019, 15 SSC, page 59. We start from 115.
What is the relevant paragraph here?
My lord, relevant paragraph will be paragraph 14. At page 119. My lord, if I can read it, your lordship. The condition of advertisement was diploma in yoga or yoga therapy. The appellant possesses a diploma in yoga education. The court exercised the power of judicial review could not come to a conclusion that the diploma possessed by the appellant does not satisfy the eligibility conditions advertised. The court has only looked to the where nomenclature of diploma possessed by the appellant. No doubt, in the proceeding of the selection committee, it is not recorded that diploma possessed by the appellant is equivalent to the educational qualification advertised. But the selection committee was comprised of experts in the subjects, and therefore, even if it was not specifically mentioned, the decision could not have been interfered only because the court finds diploma of yoga education not the same as diploma education. So what basically there is one, it is through expert, whether they give reason, what my learned friends say, how it is equivalent, they need not. It is unthinkable, my lord. They are recommending for such a responsible high post, all the experts from the university coming, and they will go only by MSc because it is quoted in that. But they will look into the overall, my lord, overall merits, quality of a person, whether he is fit for that job. And they have cleared. And the recommendation merit list, I am number 1. Coupled with the facts, my lord, record nothing there. First time it has been raised. This speaks volumes. Speaks volumes. Anything more? Now, if your lordship on terms and condition also. Now, other thing, your lordship, I don't know. Just I can point out. So far, I am concerned, my lord. I have been treated. I have been given revised pay scale every increments. Now, they are maintaining my APS, annual appraisal report or something like this, and I am scoring as high as at average 8.2 out of 10. High marks are being given. But the only problem, since I am a contractual, my probation is still late, not clear. Now my juniors, those who are B, they were juniors to me. They are now to take me, about to take me, overtake me. What is the situation, your lordships? Now terms and condition, what are the terms and condition? If you want my, I don't want to trouble. One of the terms and condition is that while you are in service, you cannot else, anywhere else. Contractual appointment or conditional service, if you are here, you cannot apply for a regular job. If you want, my lord, I can take it.
That is also stipulated in your appointment.
Appointment. So, my lord, this is like, so this is a case, my lord, because this uncertainty, my learned friend is saying nothing, I am there. My probation has not been clear, my promotion, nothing, your lordship. I am facing this uncertainty. So this is a case, my lord, from the date of my initial appointment, I treat it as permanent. And any case, my lord, he has not made out a case when we call for any interference. Oblige, your lordship.
Anything else?
And I wanted to cite one decision, my lord, but I only have one copy. If I just read two sentences only, my lord, and I'll give the reference, my lord. Only two sentences, my lord. This is 2018, volume 3, my lord. 2018, volume 3, SSC, case 55.
Para?
Ashish Kumar versus State of Uttar Pradesh.
Para?
Para 27. I'll only read one sentence, my lord, para 27. It is well settled that when there is a variance in the advertisement and in the statutory rules, it is the statutory rules which take precedence. In this context, reference is made in the judgment of the court in Malik Majar Sultan versus UP Public Service Commission, para 21 of the judgment lays down the above proposition.
But that has already been clarified. The amended rules are in consonance with the advertisement. So where is the discrepancy there?
No, there are no amended rules, my lord, to that effect.
Mr. Sen has pointed out.
That's not the rules, my lord.
Yeah, these are the rules. This is their rules, not statutory, but their internal rules.
Yes, it's their rules.
No, but
We're not talking about statutory rules. Your rules.
Letter, my lord, that letter is addressed to Tezpur Center, my lord. That is not a rules, my lord.
These are the rules, your worship. Refer to as rules.
Now, where is the contradiction here in the advertisement of the rules? Which part is the contradiction?
Rules does not prescribe for MSc, my lord. Advertisement prescribes for
What
MSc.
about that clause, the equivalent?
Yes, this is the thing.
Yes, if you go to that, then we have to define.
We have to then point out what is equivalent and what is not equivalent.
My lord, MSc is not equivalent to BE, my lord. That is.
Which you believe in?
What is your basis for that? In the context of this case.
Until unless you show it, we will not say, we will not hold that advertisement in contradiction to the rules. If you were to say maintain that contention, then you have to show us apparently which way it is.
That MSc is equivalent to BE.
Yes, that MSc is not equivalent to.
That is what you have to show.
BE.
There's two obvious, my lord.
And you have not sought to, discharge him or dismiss him from service.
That is true, my lord.
Then?
That is true, my lord.
Then are you, whether estoppel will come here?
My lord, estoppel is both ways, my lord.
You have to raise some unnecessary things. You see, until and unless there is some legal point to support it.
My lord, that is my point. Your lordships accept.
No.
It is your lordship's wisdom, my lord.
Well supported.
My lord.
You just cannot say anything saying that it is your point. Okay. Cannot leave acceptance to us until and unless you give us something worth accepting. We want to accept it, provided you this thing. You see, like you are there to enlighten us.
So we have heard the parties.
Yes, but only one thing, that there is no dispute in the bar, my lord. When it comes to qualifications, my lord, rule hold the field. Rule hold the field. But here again I am saying, my lord, it is not in deviation. It's not fatal. Only addition they have made, they have mentioned one of the equivalent. But MSc is equivalent, my lord. They have mentioned one of the equivalent. So that is not fatal, my lord. That is not in contradiction of the rule. Now who decide, my lord, the equivalent? Not us, the experts. Now they have nowhere said that this composition is not all right. Had they said no, this constitution is bad, then it would have been a different case.
Exactly.
They say composition is all right. It has gone through the expert supreme. No reason cited. All right.
See, Dr. Mojika has heavily relied upon a communication which was issued prior to the advertisement. Now, this communication doesn't say anything about qualification.
No.
It is only about with regard to whether post should be permanent or temporary post. Nothing beyond that.
It says, my lord, that communication also says, my lord, the recruitment rules should be followed as to qualification and other things.
Definitely. So if that be the thing also, is it your case that the expert panel which cleared them?
My lord, in my humble submission, this was only an interview panel, my lord.
No.
This is an interview panel, my lord.
No, but then see, if you say whatever it is, it's a selection process, isn't it? The scrutiny is there, isn't it?
My lord,
Scrutiny is there. See, the expert committee has cleared it.
my lord, I'll at the cost of repetition, my lord. Expert committee cleared on the basis of advertisement where MSc was clearly mentioned, my lord. Expert committee has not given a finding that it is equivalent, so that's why we are qualifying them, my lord.
But then,
if I'm clear, my lord, expert committee, because advertisement mentioned MSc, my lord.
But then you are saying it is not equivalent. So
We are saying it is not
how
equivalent,
to say that it is not equivalent? Also?
my lord.
If you go by your submission, then you have to say as per the rule that is not equivalent. On what basis we will hold it?
My lord, in my understanding, that was too obvious, my lord. This is engineering degree, my lord, and MSc is a science degree, my lord.
My lord, in that case, that rejoinder I will deny. Rejoinder is there in the records. I have
That is by saying equivalent. What do you mean by equivalent? Then
because BE, my lord, Bachelor of Engineering.
Yes.
Any degree equivalent to that, it must be something in the engineering, my lord. MSc cannot be equivalent to engineering, my lord.
No, this is on mere assumption. You're saying it on assumption, or you're saying it with a definite thing.
If you have formulated some sort of guidelines in this respect, then we can refer to those guidelines. But there's nothing.
Why, my lord?
Nothing in your rules. There is. You have not qualified the term.
No, so far equivalent, my lord, in my rejoinder reference. That's why I say, my lord, it has not been referred to. UGC, my lord, what are the authority to declare which are equivalent? There are two authority. One is UGC. One is, my lord, Indian Institute of NCT or something, engineering technology. I have mentioned there. They have issued recently notification. They said with the growth of, my lord, interdisciplinary approach, it is impossible for us to give an exhaustive leave of equivalent. So we leave it for the purpose of admission to the university experts, for the purpose of appointment to the selection committee. They have left it to the expert. Even they are not in a position. Those things have annexed. Somehow it is not.
If equivalence is specified somewhere,
then it's gone. Finished.
Advertisement would have quoted those.
Exactly. This cannot be mentioned.
Could not have left it like this.
Exactly. Exactly. So now it belongs to the domain of the experts. So even I have referred to it. Even they have not said how. Cannot be faulted with, because we are not in a position. Just making that it's not engineering, it is MSc. That will not do. Another thing I said, in the ministry, same post. If a lordship want, that's why I say, my lord, I can take a lordship.
Respondents in this case, in state to this thing. So far as the union is concerned, who are the respondents in this case?
In the writ petition,
in the writ petition. And who has filed the affidavit?
Ministry also have included lordships. Ministry is party.
Where do you get it, Mr. Shan?
My lord, lordship will find
page my lord,
34. 34.
34.
First title of the writ petition. The 10 respondents, my lord. This affidavit was filed by respondent number 10, I think. I'll just check it, my lord.
This is the local director of Shillong.
Respondent number 10.
He is the only person. And my appointments were made initially in Aizawl. They have no problem. This man has the problem. I don't know here.
No, the registrar has not filed any affidavit.
Nobody.
No.
Nobody. They do not. Notice has been sent to them, Aizawl, and all. Nobody has a problem. This man here has a problem.
Dr. Muzika has represented them.
Yes. And in the records, again, I am saying, my lord, it should have been reflected in the records here, since he doesn't, serious thing, he doesn't have qualification. It's not there. There was not a single communication to me ever. You do not have qualification.
Nothing on the record to show.
Nothing on the record.
This one number 9 has filed the affidavit, isn't it? Or this one
number 10, my lord.
10.
The director in Elite Shillong Center.
Now he's
connected with the
Well, at the time of the selection process, the selection, what role this director Shillong had there?
No.
Was there a center of NELIT here at that point of time?
That point of perhaps not.
It was not there.
Subsequently it came.
2010, I think it was Shillong Center was there.
The purpose is basically to ascertaining what role the director had.
Director.
As far as the recruitment process, that recruitment process is concerned in Mizoram. Because
My lord, if I can say, Your Lordship, at that point of time, 2020, it was not centralized. Now I think all has been done through the headquarters. At that point of time, it was at the level of the director. Appointments were made. But now it has been centralized from the headquarters.
You see, like, whatever way this writ petition has a bearing with this election process, isn't it? It is entirely based on that thing, which was initiated in 2010. The purpose of asking was that what role the director Shillong had at that point of time.
My lord, affidavit, basically the instruction came from the headquarters, my lord, NELIT, and he was authorized to sign the affidavit from here, my lord.
But no way it is stated, my lord, on behalf of others.
Mr.
Lordship
Sen
will take
said
note.
that record was called for and nothing was revealed for the record that there was anything about his qualification. Now that is why the court has asked that question. Otherwise, it is known to the court. For the purpose of ascertaining whether it is an individual stand or it is a stand of the department.
One more thing, affidavit. This is a very serious thing. If you want to say what my learned friend instruction from other, this is not an affidavit on behalf of others. Take note.
This para 1 I have said, my lord, on behalf of the authorized, I am competent to swear this instant affidavit on behalf of the respondents.
Affidavit, what is the affidavit of question?
Page 151.
Which one?
150.
It's on behalf of the respondents, all the respondents.
All the respondents.
It's on behalf of
But this is a fact, my lord, because the instructions came from headquarters, my lord, and because he being the local person, he was authorized to sign, my lord.
that is what normally happens.
So it is not that it is his individual stand, my lord. That I can.
No, if that is the thing, if record was called for and nothing was there in the record, so definitely this court will be interested to know on what basis that opinion was formed, that equivalency of qualification. It cannot be on the basis of one officer who had no connection with the selection process. Just somebody comes on transfer to his department and then he suddenly raises all those things. Will it be proper?
I think we.
But my lord, equivalence of BE and MSc is too obvious, my lord. If your lordship permitted me to that effect at this stage also I can substantiate that, my lord. Some certificate from IIT or NIT, my lord, that MSc is different from Bachelor of Engineering.
If your lordship, my lord, so far this is concerned.
MSc is a master's degree, my lord, in pure science, in science subject. It's not an engineering subject, my lord.
You are forgetting the basic. The basic factor here is the advertisement. In the advertisement, it's clearly stated that MSc is there. So,
advertisement clear. Our only case is on the basis of that Supreme Court decision, which says that in case of conflict between advertisement and the rules will prevail. Advertisement will not prevail.
I will not presume there is any conflict in view of the fact that you have at no point of time you have recalled this evidence. You have not done anything. Rather, you have confirmed somebody who approached the court who were recruited on the basis of this evidence.
They met the qualification, my lord.
But then
Itanagar people.
temporary.
My lord, there the question was temporary or permanent, my lord. The qualification was
how
not
many,
missed.
into how many pieces we will break this advertisement? For this purpose, it will be this. For this purpose, it will be this. Is it?
Only two angles were there, my lord. One is covered by Itanagar, my lord.
Will be something
Only
like
qualification was left, my lord. That will be covered by your lordship's order, my lord.
Yes, my lord, if your lordships, I don't know, my lord, lordship will look into whether there are infirmity in single judge order or not. So I have just pointed out, my lord.
Prime thing we have to look into that.
Exactly, your lordship. Only thing, my lord, though it is not reflected in the judgment, because he is insisting on equivalent, your lordship. Now, equivalent, that rejoinder also matters, if your lordship can, because since it is on record. There I have seen in the ministry same post, not controverted, same post, same pay scale. That the prescribed qualification, one of the equivalent qualification is, my lord, prescribed equivalent qualification, MSc in computer science. It's not controverted. That is in the ministry, same ministry which is controlling this society. Now he is saying so easily. There are there is also, my lord, BTech and all, or MSc in relevant field, there is computer science. Am I next sense? So I am not saying, my lord, that I do not fulfill the requirement of the rules. Then I am gone, your lordships. Because if I say that this advertisement is not fatal. They could have avoided mentioning MSc, just equivalent, left it to there. But they have mentioned MSc, it is not fatal for the purpose. Because it is otherwise equivalent, and most important thing, it has gone through the experts, my lord. They have formed an opinion. They may not have given reason that is good enough. And that's what the Supreme Court said.
They
We
have
should
never sought to terminate you on the basis of qualification. Rather, they kept on extending your. Exactly. So what it would presume? That means you hold equivalent qualification. Where is the question?
And they cannot also question, my lord. Once the expert has recommended me, they cannot.
The only issue before the department now is whether you are to, to continue as on temporary or contractual basis, or your employment is to be regularized
on permanent basis. My lord, in view of same thing has been done to others with effect from date of joining.
That is the only issue.
Yes, that's what the learned single
question
judge
of
has also
qualification and other things doesn't come in the picture.
My humble submission is, but since he is not equivalent, he is still saying MSc.
It doesn't say that because you are not qualified.
I don't know. The
MSc
expert,
is
even
not
for me, I
equivalent.
cannot comment on.
Therefore,
that.
you cannot be. You can no longer be, posted as a contractual or, a temporary employee. That is not the case.
And one thing, of course, when my learned friends say, suppose I do not have the qualifications, and suppose MSc or equivalent is not prescribed there, then with that long lapse of time, we will not cure it. It will still remain an illegality. That's why I am saying, my lord, I am as per the rules. It's not that. And this advertisement, my lord, is not fatal by mentioning MSc. This is equivalent. Oblige, your lordship.
Wait for the parties.
Yes.
That means, sir.
Item number 3.
Oblige.
Please, Your Lordship. Your Lordship, I pray for short accommodation, Your Lordship, as the conducting counsel is in his post.
It was for the state to clarify certain things.
My lord.
What happened?
My lord, we have received a letter from the department.
Is it from the date of?
The letter says that it is from the. It will be considered from the date of the issue of the letter. The date on which the letter was issued.
So then that means like then this matter would be this thing. We'll have to the heart of mail.
My lord. In fact, my lord, because the additional affidavit that we had filed in the writ petition, my lord, there we had stated that the petitioner was taken under the RCW status only in the year 2021, my lord. So that being so, my lord, as per procedure, she would otherwise be qualified for RCW status only in the year 2031, my lord. But nevertheless, my lord, so far pursuant to the directions of this Honorable Court's order, the department has given some consideration. So, my lord, only to that extent, my lord, it will be considered from the date of issuance of that letter.
No.
They have sought for condition. On pre-made by the letter counsel for the appellant seeking accommodation in this matter. The matter is adjourned. This is same after 2 weeks.
Obliged, Lordship.